Good morning, everyone. I'm very pleased having this speech today, not only to be polite and to be nice, but for me as a lawyer it's very interesting and exciting to be part of this technical evolution we're actually in. So the data protection reform was started some years ago in the European Union. This law will come next year. Switzerland will follow in most part of this. And when I was preparing today's speech, I thought for myself it would be good to provide you with an overview of what's coming, what companies have to expect for the forthcoming years. At the end of the day, I had to a little bit change the title, so I put a question mark on it. Is it really a new landscape we are facing? Maybe it's more a new hope. So the good news is, yes, there are some new issues coming. In general, the idea of this new reform is to strengthen the one's individual's rights over controls over data. And there are some other fancy tools coming with respect to the privacy by design, privacy by default. You may have heard that. There are some other tools coming for companies. They have to face, however, to some severe, more accountability, more compliance issues. However, these new tools which are coming, the core concept of the Federal Act of Data Protection, the Data Protect law, will remain. And I will today not make an exciting journey about every detail which is now coming, but to pinpoint the most important issues companies have to face with respect to these core principles which are essential. Well, I don't have to introduce again myself, otherwise please feel free to find us on LinkedIn. Maybe just short, Siteagility is a IT and legal consulting company, so we provide the whole architecture, we design the architecture and the development of big data infrastructure, and we also provide legal and governance issues to our customer implement them. So please feel free to visit us on our website. Mark Zuckerberg said once in 2010, privacy is dead, so get over it. Today, we are in the eve of an updated data protection reform driven by the European regulator. As I mentioned before, Switzerland will follow this direction in most part. The Department of Justice just published their first draft, this Federal Act on Data Protection, the FADP. As mentioned before, today I don't want to provide you with all the details, but just with the pinpoint of the most important issues. So from a technical perspective, the automated processing of huge amounts of data from multiple sources continues to grow. So it's not surprising that the data protection law has become a local point of legal protection in both privacy and academic literature. So the current data protection now we are dealing with was set in force in 1995, but the background for that law was set in the 70s. So just to make that point clear, companies have to deal with a legal framework which was established in the 70s, so when the internet was completely out of scope. Now, I assume most of you have a wearable on you, right? Your smartphone, your iPhone, and of course you have some fancy apps on it. And every time you use that app, they may track your location. They may have access to your photos. They may have access to your business calendar, to your contacts. They may track what you browse and when, with whom you are in contact, how regular, etc. So nowadays, there's nothing special, right? If you want to activate your voice assistant, for example, Google Assistant, you have to say, okay, Google. Now, are you aware that Google is listening all the time, even though your smartphone is on standby? There was an interesting case some weeks ago in the US where a criminal could be found guilty because he has activated his voice assistant. So the prosecutor was able to get this data to figure out and evaluate where this person were and has been and what he had said. And some of you may remember the film Minority Report with Tom Cruise and made by Steven Spielberg. Which year was this? It was 2002, so 14 years ago. At that time, this was pure science fiction. Nowadays, it's not. The US-based company Protocol designed a new software to predict crime. So this software is used with many policy forces now in the US for quite a long time. And even though it's not the idea to pick up criminals and put them into jail, it helps policy forces to structure their resources and bring them to the hotspots. And it's not only in the US. The University of Fribourg under Philippe Peter-Mouron just published some weeks ago a study exactly about crime prediction. So in this study, it could prove an accuracy of crime prediction of more than 80%. Depends a little bit on what kind of crime we are speaking here, but the general idea is absolutely clear. Now the European regulator has taken up this challenge and updated the legal framework. As mentioned before, there will be this new GDPR, which will come into force in May 2018. Switzerland will follow with their FADP, the Federal Act on Data Protection, around spring 2019. The focus, as I mentioned before, is to strengthen the control of an individual to control their data. This is the concept of this informational self-determination. Many companies then have to face this new accountability and compliance standards. This includes requiring them to maintain certain documentation, conduct a data protection impact assessment. They will have to implement privacy by default and privacy by design tools. So there is also then the federal commissioner, the authority overlooking data protection, will have more resources, more competences. He has the right to impose fines up to 500,000 Swiss francs each incident. He has the right to investigate independently within companies if a privacy breach occurs. Now, this sounds all very good. However, there is a problem. The trouble with the European as well as with the Swiss data protection law, which will come into force, is that it's dead. These new tools which will come will only have marginal effects on the current data, how companies process data nowadays. So the data protection letter, as it stands now, is a dead letter. Current ideas, what to do with that body, relating to nowhere. Now, I'm exaggerating here, of course, but in today's speech, exaggerating serves the function to make my point here and to clarify my arguments, which are as follows. First, this core concept, informational self-determination, is not the right concept to deal with data processing in the 21st century. How companies work and process their data. We'll come afterwards to that in detail. The second issue is, and this is from a lawyer's perspective, very interesting, one has not to be very visionary to see there is a huge distinction between laws in the books and law in action. And the regulator, his only idea is to put more laws in place, and especially more of the same law. So he has little done to prevent the development of massive databases and the advent of big data era. And this leads then to the third issue, to profiling, which we all have a closer look on. If we step one step back and look what are the roots of the data protection, it's using our Constitution. The Federal Constitution, you can read here in Article 13, and if you go to paragraph 2, you can read every person has the right to be protected against the misuse of their personal data. The misuse of their personal data. Now, the Federal Supreme Court, the highest court here in Switzerland, decided, no, it's not about misuse of data, it's about the right of informational self-determination. To visualize this concept, you see here on this side, It's kind of a bubble around a person, and a very huge bubble. So if a company wants to process data, they have to enter into this bubble. But they cannot unless they have the right to do so, especially when a person gives their consent to it to process this data. In Switzerland, it's quite the other way around. Yes, we also have here a bubble, but a very small bubble around the person. So we only protect, really, it was the general idea, I have to say. It was the idea to protect just a small values around the person. Now, data protection is not synonymous with informational self-determination. However, for many, the two are very close related. If you want to look for a definition of it, this definition would be, it is the right of the individual to decide what information about him or herself should be communicated to others and under what circumstances. This goes back to James Weston, US American lawyer, back in the 70s. Now, this concept of self-determination implies two things. First, that individuals can provide their consent, and a free and informed consent. And second, that individuals have various rights to exercise those rights, such as the right to correction, such as the right to erasure. Now, in what world do people live who claim that individuals are really able to exercise control over their data? So exercising control over data is very hard to achieve, when not impossible. Why is that? Big data and big data analytics is unforeseeable. Yes, there are still simple situations in which companies process a relatively small amount of data for a small set of personal data to a relatively clear purpose. But as databases, profiling, and the big data era evolves, these situations will be few and far between. So most practices involve multiple data controllers, processing of sharing sets of data for multiple, not seldom fuzzy purposes. Think of cloud computing, for example, or profiling. You come to that at the very end. So how can one effectively exercise the right to be informed, the right to access, the right to correction, the right to erasure in such practices? The regulator has recognized now this gap, as I mentioned before. But as I said, the only solution he has for that is to implement more laws, and specifically more of the same laws. And so that means that there is a huge gap between law in action and law it's in the book. So at the end of the day, we also have to face with the status quo. So it's time for a closer look. Data protection legislations embodied the concept of data minimization in the current data protection law, and it will also stand in the forthcoming laws. So this law says that organizations should minimize the amount of data they collect and process at the length of time to keep the data. Now think a moment for all the data you have in databases, and it's not only Google and Facebook. It also includes databases you do not really know, or you can reasonably assume. That means almost every online provider, but also many other companies which become more and more data-driven. So in 2010, the total amount of information processed worldwide was estimated by 1.2 zettabytes. This number will double all 2 years. Estimation is for 2020 to be around 40 to 50 zettabytes. At the same time, around 15 billion things will be connected to the internet. So now I want to spare you with a closer look at what big data is, but it's fundamental to understand. It's not about only volume, it's also about velocity and veracity. Even though the current data protection law and the report made for this new reform refers literally to big data, so they mentioned the big data, so they're aware of big data, what big data maybe is, the core elements will not change. So the laws coming forward does not reflect these four main characteristics of big data. Another concept will remain the same, the distinction between personal data and all other data. Personal data is when you can directly identify a person by, for example, name or their social security number. More tricky is then when is a person identifiable. When you had only structured data, it was usually quite easy to anonymize data. You just had to, for example, erase specific pieces inside data. But today, as companies can process semi-structured data and unstructured data, this core concept of anonymization, and with that the distinction between personal data and all other data, is not really workable anymore. Now, of course, much of that of data is not really personal related, but big data analytics may discover unexpected correlations, for example, between data of people's lifestyle and their credit worthiness. The capacity to store data increases all the time, and the cost of storing is falling. So, if I quote George Dyson, big data is what happens when the cost of storing information becomes less than the cost of throwing it away. And the ability of big data analytics to process huge volumes of data may encourage companies to keep data in a long run for historical data, which makes absolutely sense. So who in his right mind can look at the world out there and claim that the principle of data minimization exists? This relates then to the second core concept, the purpose of data processing. Personal data may only be processed if the purpose indicates at the time of collection, of the time of storing, that it is evident from the circumstances or that it's provided for by the law. So the concept of the purpose of data processing will not change. Think about when you install an app on your smartphone. Every time you have to push the button, yes, I agree. To what do you agree? I mean, whoever read privacy statements, whoever read terms and conditions, they're not there to be read. They're not there to be understood. However, the purpose is indicated there. It's written there what companies might do with your data. Now, throughout big data analytics, data is hardly covered by the purpose indicated at the time of collection of data. The data controller is looking for correlations between data at the time of processing, not at the time when data is stored, especially if companies establish concepts like a data lake. In consequence, the data subject, people using specific services, cannot be aware of the related data and to what purpose data will be processed. With respect to the consent, and this is the third concept after data minimization, the purpose of data processing. The most obvious way that a person can allow data processing is giving their consent. But the consent has to be freely given, it has to be specific, it has to be informed. So indicated and they agree for the processing. This means that people must be able to understand what the organization, company is going to do with their data at the time when the data is stored. Now, I argue that the concept of information and consent is here largely theoretical and has no, or at least not much practical meaning. It is generally recognized, as I mentioned before, that people using services, they just tick these privacy accepted statements. If you Google search, if you're using Google search, for example, you even have to put a button. You just use the service and with that implicitly agree to the privacy terms of Google. Now, surprisingly, however, the conclusion is too seldom drawn that consent is simply not a suitable approach anymore to legitimate data processing in online context. So many scholars and policymakers seem simply to suggest ways to make online consent more informed, more conscious and more mandatory for providers. Even though if you don't read them, if you don't understand them, what's the meaning of giving a consent? It's not specific, and it's not informed. This leads us to the last point, profiling. Now, the new data protection law aims to regulate profiling, which says in simplified terms that a person has the right not to be subject to decisions based solely on profiling. Profiling is a know to generate knowledge by means of algorithms for patterns of correlations between data. So the correlation stands for a probability that things will turn out the same as in the future. They provide a kind of a prediction based on past behavior. The term profiling stresses out the following main points. Individuals have the right not to be subject to a decision when it is based solely on automated as well as manual profiling. It is kind of a distinction here in Switzerland. In Germany, it is focused only on automated processing. Here in Switzerland, we say also profiling is within the law when it is manually done. So, personally, I do not understand how this is really workable. Second, it must produce a legal effect or a similar significant effect on individuals, even though this kind of terms, it's absolutely unclear what the regulator meant with that. So I think we have to figure this out in the forthcoming years. If processing of data falls then within that definition, profiling, it's a breach, in general, it's a breach of privacy. And the issue here is it's a very broad definition what profiling is. At least we have to say profiling, it's now the first time explicitly mentioned within the law. So up to now, there is no profiling in our legal world, even though companies do it since many, many years. This seems to suggest that the data protection law will be extended and regulate profiling at large, which is unfortunately not the case. There are several loopholes, huge loopholes, and it must be. Otherwise, companies like Facebook, Google, and other companies which use data would have to close their doors. So the right profiling does not apply if the decision is necessary to entering performance into a contract between the company and the individual. It would be authorized by law, which is for company maybe not that interesting, or again, it's based on explicit consent. Now, the one key feature is also missing within the definition of profiling. It's the last point here, this group profiling. So, the expected law just makes a definition of individual profiling, but not group profiling. So, for example, a health insurance company may be interested to make kind of a template profile about smokers. They have indication, or they put specific attributes and characteristics on smokers, saying the probability that if someone smokes over a specific time period, will have cancer, and what costs results from that. So if then a prospect comes and wants to make a contract with that health insurance company, a new policy, they put this profile template to this individual, which would be most likely out of scope of this new law, or they also put it to the group of persons saying what kind of marketing measures we are planning. Now what to do? This leads to the last issue here I want to present you. Data protection law has a communication problem. It does not have a particular positive connotation to companies, right? Companies do not see data protection as a basic of reasonable rules. Companies see data protection, in my experience, mostly as an obstacle and then as a nuisance. And if you compare it as a traffic light, the traffic light is mostly red-orange instead of orange-green. So why is that? This is a complete miscommunication. It allegedly only restricts companies of doing new businesses instead of enabling companies. So it's quite common understanding that the data protection law protects fundamental human freedoms. However, this is just one part of the paper. It also stimulates the free flow of data. And this latter, this free flow of data, new possibilities, is mostly overlooked. So data protection is not red-orange, it's orange-green, and that's what we communicate to our customer, that it's not about stopping projects, but it's enabling companies faced with these regulations that they implement from the beginning of a project, a proper legal and governance framework. So that not at the end of the day, they have a project will be stopped. Now what you do, first get rid of this new concept of informational self-determination, focus on privacy. Companies should implement a well-designed legal and governance framework. This means more policies and more procedures. But implement then good practice tools and frameworks such as privacy, the impact assessment, as well as tools like privacy by design and privacy by default. Good. That's it. Thank you very much.